Welcome, and thank you for participating in today's webinar, Virginia's Climate Change Strategies, Addressing Climate Change in a Fractured Legal and Policy Environment. This course is co-sponsored by the Virginia Coastal Policy Center and the Virginia State Bar Environmental Law Section. I'll now turn it over to the Director of William and Mary Law School's Virginia Coastal Policy Center, Elizabeth Andrews.
Thank you, Mallory, and good morning, everyone. We're excited you could join us. We have a good turnout today because let's hear it for lawyers who leave it to the last minute. All of us are always guilty of that. We are excited to again co-host a CLE with the Virginia State Bar. We did this last year as well. In fact, the video is available to you in their blitz of free CLEs this fall. And this video will be posted later on our website, but not for CLE credit. Later on, if you watch it after the year and when it's posted, it won't be for CLE credit, but will be there for your reference. We're very excited to have an array of good speakers with us this morning. I'm not going to take the time to read their bios. They are in your handouts. So to save time, I won't go through them all, but we're excited. Joe Romero's with us from Van Deventer Black, and also Justin Williams from the Department of Environmental Quality, Carrie Atwood from the Virginia Department of Health, and Ben McFarland from the Hampton Roads Planning District Commission. So we have, as you could tell, an excellent array of private law firm, Virginia state agencies, and the regional PDC perspective. So we're excited about that. And with that, I'm going to hand it over to Joe to start us off.
Thank you, Elizabeth. Welcome, everybody. I hope you find this presentation useful. What we're going to talk about in the beginning here is where we find ourselves today in the United States under U.S. domestic law at the federal level primarily, and why the inability to implement uniform national greenhouse gas regulations or legislation has resulted in the diffuse and fractured legal environment that we find ourselves in today, where most action is actually occurring either at the regional, state, and often at the local level. But we don't have that much time to cover a lot of material, so I'm going to start off. I will say that I'm not going to read all the slides. The material in the slides is really there for you to serve as a reference point for later use if you need additional information. And as always, feel free to ask questions either now or reach out to me after the presentation. I'd be happy to answer any questions you have. I wanted to start off just a little bit of, for those that don't have the appreciation of some of the history with regard to climate change and where we find ourselves today relative to the legal framework that at the national level. I will say that in the beginning, when there was light and God said it was good, climate change science actually, for those that may not know, was actually fairly well settled as late as the late 19th century to the early 20th century. And there really wasn't a lot of debate as to its validity. It went dormant for a little while until the Cold War, when climate science really exploded, in large part because of information the military required. And that information that was garnered as part of the scientific study into greenhouse gas emissions and climate change led to a fairly uniform and bipartisan effort in the United States, and the United States' fairly active participation on the international scene. I'm sure everybody knows that shortly after the Earth Summit, you had the United Nations framework for the United Nations framework for climate change that was enacted. The U.S. as a party, and under that framework, you had the United States as a key negotiator for the Kyoto and then subsequent Copenhagen protocols, although the United States did not join Kyoto for a number of political reasons and because of disputes relative to the emission standards for emerging greenhouse gas emitters such as China, India, Brazil. Still, after some movement, the international community negotiated the Paris Climate Accords, which the U.S. did join, provided notice it was withdrawing, and then withdrew the notice of withdrawal, so the U.S. is still a party. And the U.S. has been contributing its nationally determined contributions to Paris, or under Paris, excuse me, to identify its strategy for reducing greenhouse gas emissions. On the domestic front, again, Congress, the legislative and executive branches really, there was not a lot of dispute relative to climate change, at least in the beginning. Through the 1970s and 80s, there was a bipartisan effort to pass a number of legislative initiatives to fully understand the scope of what was happening and the impact on the United States, its economy, and its society. Unfortunately, starting in the late 1990s, I think everybody recognizes, or the mid to late 1990s, there was a shift in tenor in Washington to probably a more divisive partisan discord. And unfortunately, climate change science and the climate change discussion got caught up in that, much like a number of other issues. And so that resulted in the context into which our fractured legal environment has evolved into. So with that said, the crux and the beginning of real efforts to address climate change through domestic legislation actually started as far back as 1998, where then General Counsel to EPA, Jonathan Cannon, issued a memorandum in which he opined that since there was no other federal legislation that was foreseeable with regard to tackling climate change, that he analyzed the existing authorities under the Clean Air Act to determine whether or not climate change and greenhouse gas emissions can be regulated. And he concluded that greenhouse gas emissions fell within the definition of an air pollutant under the statute's broad definition of such. And so he opined to EPA that yes, the agency did have the authority, although not the requirement, to regulate greenhouse gases. Unsurprisingly, as a result of that memorandum, a petition was filed under the Administrative Procedures Act by 19 organizations requesting that EPA move forward with regulating greenhouse gases under Title II of the Act, specifically Section 202 with regard to mobile sources. And they relied specifically on the Cannon memo. What does Section 202 of the Clean Air Act required? It requires EPA to develop emission standards, as you see there, for any air pollutant from new motor vehicles, in which, and this is terminology that'll come into play in a bit here when we talk about Massachusetts versus EPA, which in the administrator's judgment causes or contributes to air pollution that can reasonably be anticipated to endanger the public health or welfare. And so relying on the Cannon memo, the petition to EPA requested that EPA make a determination under Title II, specifically Section 202, make an endangerment finding. And of course, as with many things in Washington, the political wind shifted. There was a new Attorney General in 2003, Mr. Robert Fabricant, and he issued a memo in 2003 that contravened or essentially overruled the Cannon memo and said that the analysis was incorrect and that, in fact, EPA did not have the authority to regulate greenhouse gases, primarily because Congress never envisioned that the Clean Air Act would be used to regulate an emissions or an air pollutant that was so ubiquitous that really the Clean Air Act was envisioned to tackle discrete large sources. So EPA denied the petition in 2003. And sure enough, in our environment, our litigious environment, these interest groups and a number of states filed suit. And the named plaintiff, Massachusetts versus EPA, is the threshold case with regard to greenhouse gas regulation, or at least the treatment of greenhouse gas under existing Clean Air Act authorities. And so the first thing that the Massachusetts court did was a divided court, 5-4. It, like most courts, it began an analysis of standing and justiciability and whether or not the court could actually render an opinion in the case. I'm not going to go into it in too much detail, but it did establish, based on what it claimed was historical precedent, that the states, as what it called quasi-sovereigns, had a special solicitude or special standing that even if it may not have met the traditional criteria for judicial Article 3 standing that had been articulated by the Lujan opinion, that Massachusetts, in its role as the sovereign, protecting the interests of its citizens and the territory and the air for which it was responsible for, similar to a public trust doctrine argument, that it enjoyed a certain standing that allowed it to present its case to the Supreme Court. It then went ahead and essentially dissected many of the EPA rationales for not making an endangerment finding, including, for example, EPA argued that greenhouse gas emissions and climate change was a generalized harm. And as a generalized harm, the named plaintiffs could not articulate a particularized and concrete injury to them, and therefore didn't have individual standing. The court basically set that aside and said that the complaint was well pled, that particularly Massachusetts even Massachusetts, even in its quasi-sovereign status, did articulate individual particularized injuries to itself, such as loss of coastline that are state-owned. The court also reasoned that although regulating greenhouse gases for mobile sources only, because that's what the petition asked for, wouldn't address the larger problem of climate change in and of itself, that a court did not have to render a decision only when it could resolve the entirety of the problem. In other words, the court could provide judgment and remedy to the named plaintiff, even if that remedy didn't make the plaintiff entirely whole. And so then the court also went on to note that, oh, by the way, the transportation sector is, other than the electric generation sector, the largest source or the second largest source of greenhouse gas emissions in the country. So there was sufficient causation there to allow the plaintiffs to get into the court. And then finally, the EPA made it provided a pretty extensive argument that, you know, the agency has discretion here, that the administrator, the statute specifically said that the decision on endangerment rests on the judgment of the administrator, that the administrator exercised that judgment, and in the administrator's judgment, that it was not prudent at this time to regulate greenhouse gases. And the court addressed it in one of two ways. The first way was to note that, EPA also said that, you know, when it comes to regulating anything, that it's a form of enforcement, and then the agency has enforcement discretion. That's a fairly established canon in law, that regulators and law enforcement agencies have wide swath on whether or not to enforce a law or regulation. But the court said, no, we're not talking about enforcement here. We're talking about regulating. And when it comes to regulating and rulemaking under the APA, that's not where the discretion lies in this case. And specifically, that leads us to the merits of the case. And that is, what the court did is the court looked at, first off, what is the definition of an air pollutant under the Clean Air Act? And it's pretty broad. The general definition of air pollutant means any air pollutant or any air pollutant that it's emitted into the ambient atmosphere. And so as a result, the court said there's no statutory reason why greenhouse gases couldn't fall within that definition, because carbon dioxide, while it may be emitted by natural sources, was also emitted by all kinds of other sources, and it was any agent that's being emitted. The next thing the court did was then tackle that very issue with regard to judgment. And the court ruled that, yes, the administrator has judgment, but what EPA did in this case is it misapplied where its judgment fell. EPA argued in its denial of the petition that it had judgment to make the endangerment finding in the first place. And EPA said, no, you don't have that judgment. Your judgment lies in whether or not to make the substantive endangerment finding based on the information before the administrator. In other words, EPA under the statute is responsible for making a determination whether greenhouse gas emissions do or don't endanger the public health. But EPA did not have the discretion to not make that judgment. The court also, and I want to bring this up specifically, and that's the Williamson Tobacco case, Brown versus Williamson Tobacco. And in that case, EPA, I'll take a step back. EPA had argued in its denial of the petition that the Supreme Court's case in Williamson Tobacco precluded it from regulating greenhouse gases because to do so would have expanded EPA's authority under the Clean Air Act into areas that Congress never envisioned EPA would go into, and would be their regulations of greenhouse gases would be so invasive that would fundamentally transform EPA's statutory role. And they relied on the Williamson tobacco case because in that case, the Food and Drug Administration issued a rule to regulate tobacco as a drug. And the court in Williamson Tobacco struck that rule down, saying that whether or not tobacco as a substance could fall within a definition of a drug under the Food, Drug, and Cosmetic Act, there's no evidence, and Congress would not have envisioned, in light of the ubiquitous nature of tobacco use, particularly at that time, that FDA would make a move that would essentially ban tobacco and affect large swaths of the economy when Congress was fully aware that tobacco use was so prevalent in our society. And so based on that, the court ruled that EPA's rationale for denying the petition was not sufficient, and ruled that sent the issue back to EPA to basically said, you need to make an endangerment finding. Now, the court didn't say you had to find that greenhouse gas emissions endanger the public health, but it did require that EPA make or act on the APA petition relative to this issue, make a determination as to endangerment. There are two dissents in the case. I'm not going to spend a lot of time on them because we don't have that much time to cover them. Chief Justice Roberts, if you want to review a critique of the court's rationale, specifically with regard to whether or not a state enjoys a special category of standing, his opinion is a pretty interesting read. Justice Scalia, I wanted to talk about a little bit more because his dissent actually is a little bit of a preview of what's going to happen 7 years later after the Massachusetts case. And in his opinion, Justice Scalia argued that the court actually in itself misapplied where the administrator's judgment is. Because yes, EPA, when it makes that judgment with regard to endangerment, the judgment has to pertain to the endangerment finding itself. But as Scalia argued, there's nothing in the statute that forces the administrator to actually make that judgment call. And he addressed the Williamson tobacco case a little bit as well. And again, I wanted to put that marker down because you're going to see that issue arise again in a bit. So what happened after the Massachusetts case? EPA issued its endangerment finding. And there's a cool screenshot. Anybody, if you want an opportunity to read it, there's the citation. It's fairly lengthy, but the first, I'd say 20 pages are the meat of it. It's a good summary of the bases under which EPA relied on for making its endangerment finding, that greenhouse gas emissions do endanger the public health. And it actually went through a fairly lengthy analysis relying on United Nations IPCC reports, analyses by the US's own greenhouse gas national inventory and findings and climate change analysis, and the science that had been developed as part of the legislation that had been enacted in the 70s and 80s. Using all that information, the EPA went through a sector-by-sector analysis on how greenhouse gases and its effect on the climate would affect the United States and various areas of our society, including the economy and health, forest lands, you name it. So with that said, so what next? So now you have the endangerment finding. Let's make sure. There we go. So again, there's no overarching statutory authority to regulate just greenhouse gases. So the administration is, and then we're talking about the Obama administration, is looking at a way to then use its existing authorities to regulate greenhouse gases. And really the only statute that is relevant with regard to greenhouse gases directly, there are certain statutes kind of on the periphery that you might be able to use, but really it's the Clean Air Act. So what EPA did is, through the endangerment finding, it found that obviously greenhouse gases endanger the public health and welfare, and that triggered a requirement to regulate greenhouse gases emissions from mobile sources. And so the administration began that process to issue motor vehicle emission standards in coordination with DOT that issues motor vehicle mileage standards for joint rulemaking on greenhouse gas emissions from motor vehicles. The interesting interplay in the Clean Air Act is once greenhouse gas emissions became a regulated pollutant under Title II, arguably became a regulated pollutant under Title I, and specifically under Section 165 of the Clean Air Act, which is the PSD program, which is the Prevention of Significant Deterioration program. And under the PSD program, the statute requires best available control technology for each pollutant subject to regulation under the Act. And so and this is one of actually EPA's arguments when it denied the petition, that once you regulate greenhouse gas emissions under Title II, it immediately required regulation of greenhouse gases under Title I. Well, not necessarily immediately. We're going to get to that in a second. So the question then became for EPA is, when would greenhouse gas emission requirements under the PSD program be triggered? Because as we all know, greenhouse gas emissions are a ubiquitous gas emitted by everyone, you, me, all kinds of sources. And the Clean Air Act, particularly the PSD program and the Title V program, were never envisioned to regulate an emission, an air pollutant, at such quantities. Stationary sources are regulated. The Title I really is focused on major sources, those sources that emit anywhere between 100 to 250 tons per year, depending on the type of attainment area you might be in. It really, the PSD program, the Title V program, was intended to regulate the few hundred or a couple thousand sources throughout the United States where that are emitting large amounts of what I would colloquially call conventional pollutants. Once you start looking at greenhouse gas emissions, you're looking at regulating hundreds of thousands of sources at those statutory thresholds of 100, 250 tons per year. When you're looking at relatively modest sized residential buildings are now going to be triggering those emission standards, and in theory would be major sources. EPA obviously knew that. EPA knew this was going to be a problem. There aren't enough permit writers in the universe to address or prepare Title V permits for orders of magnitude increases in the number of major sources in the United States. So EPA needed to buy time to figure this out. And to do so, it issued what is known a series of regulatory actions, the first being the triggering rule. And it said, look, although the endangerment finding might have arguably triggered Title I PSD permitting requirements for greenhouse gases, we're going to interpret the PSD program as requiring the triggering of greenhouse gas standards when the greenhouse gas standards for motor vehicles go into effect. That will be the trigger. And so then EPA followed the triggering rule with a tailpipe rule. Now that's the rule that was jointly developed by EPA and the Department of Transportation in order to develop the greenhouse gas standards for motor vehicles. And in that rule, it said that greenhouse gas emissions for motor vehicles will go into effect on January 2nd, 2011. That's the day that would trigger greenhouse gas emissions requirements under Title I of the Clean Air Act. Then came probably the most, not probably, the most controversial of the three rules, which is the tailoring rule. And that was EPA's attempt to try to tailor the greenhouse gas emissions and essentially shoehorn it into definitions of major source by essentially through regulation, increasing the threshold of emissions required to be regulated for just greenhouse gas emissions, which is going to cause a problem, as we'll see. So of course, as you can imagine, any new regulation is going to immediately be followed by new litigation. And so trying to click the slide here. There we go. And sure enough, Utility Air Regulatory Group, the special interest group that represents stationary source emission sources, filed suit against EPA, and they won in 2014. And what did and this is commonly called the UR case. So what did the court rule in UR? It's kind of interesting. The court basically said, and this was penned by Justice Scalia, and he wrote, when is an air pollutant not, he didn't write this, but my commentary is, when is an air pollutant really not an air pollutant? And what Justice Scalia, the main crux of his rationale was, although the Massachusetts court, and you can almost see him biting his, gnashing his teeth when he's saying this. Yes, okay, fine. We have this Massachusetts case that ruled greenhouse gases are subject to regulation under the Clean Air Act, and then you have the endangerment finding. But just because greenhouse gases meet the statute-wide definition of an air pollutant doesn't necessarily mean it meets the definition of an air pollutant for the individual subset programs resident within the Clean Air Act. So pursuant to Scalia's rationale, the various programs established under the Clean Air Act, such as PSD, such as Title V, the definition of a regulated air pollutant for those programs isn't always going to be the same as the larger definition, the statute-wide definition is what he calls it. And in many cases, and he cites to some arguable examples as to the EPA's past conduct in this regard, where EPA defined air pollutants, a more narrow family of air pollutants to regulate under various programs. But what's interesting is where the Massachusetts court essentially discounted EPA's argument with regard to Williamson Tobacco. This is my again, Justice Scalia's revenge, and there's a little bit of a preview in this in the Massachusetts dissent, which he specifically hammers home the Williamson Tobacco argument that said, at least with regard to stationary sources, he's already had to concede mobile sources in the Massachusetts, but at least with regard to stationary sources, and specifically stationary sources under the PSD and Title V program, Congress would never have envisioned that the Clean Air Act and those programs in particular would have ballooned in such a way as to include basically the entire U.S. economy, and would have expanded EPA's power in a way that Congress in no way would have intended. And I have the quote there by Justice Scalia that anytime a regulator comes in with a finding a significant power in an old statute, they're going to greet that with some suspicion. So I'm going to start getting through this real quick. So because there's not a whole lot more to say after this, because after the UR case, that case essentially ossified regulation of stationary sources. The Obama administration attempted under the NSPS program, the New Source Performance Standard program, to establish greenhouse gas emissions for electric generating units. I'm not going to talk a lot about the Clean Power Plan. You can look that up if you need to. And the reason I'm not going to talk about it is because it was set aside. Under the Trump administration, they issued the Affordable Clean Energy Rule, whose purpose was to repeal the Clean Power Plan. And it really narrowed what type of control technologies could be implemented to regulate emissions from stationary sources. But I'm not going to talk about that much either, because that was also set aside by court. The DC Circuit set aside the ACE rule, and that's where we find ourselves at this point. The administration issued a last-minute rule called a significant contribution finding. I'm not going to talk about it a lot, because again, the Biden administration withdrew it. That rule would have curtailed the ability of the EPA to regulate greenhouse gas emissions outside of electrical generation units, but that's also been withdrawn. And so where we find ourselves is where we were in 2014, which is EPA is essentially free to regulate mobile sources, which it has. In fact, it's issued its greenhouse gas emission standards for motor vehicles for the next model year. It issued regulations for greenhouse gas emissions for aircraft to comport with ICAO rules. And one thing I did fail to mention is under the UR case, Scalia did concede that if a source is already regulated as a major source for conventional reasons, that there's nothing in the statute that prohibits EPA from also including control technology for greenhouse gases or any waste sources. So EPA is in fact regulating any waste sources or greenhouse gas emissions from them, from traditional Title V major sources. But that's it. So as of right now, there is no national uniform legislative or regulatory structure for greenhouse gas emissions. which is why most of the activity you see with regards to controlling greenhouse gases are at the local regional level. And with that, I'm going to turn the floor over to Elizabeth.
Thank you, Joe. And now that you've heard the somewhat convoluted path we've taken at the federal level to deal with climate change impacts, I'm going to tell you about the somewhat convoluted path we've taken at the state level to deal with greenhouse gas and emissions, climate change impacts, et cetera. I'm going to talk about funding and planning and research, and then a few of the challenges that we're still facing. So for funding, it started in 2016. The state created, Senator Lewis had a bill that created the Shoreline Resiliency Fund. And it was a great idea in that it was to provide funding to the local level to engage in resilience projects that actually could reduce future risk as well. It was a very forward-looking piece of legislation, but the problem is that it created a vessel that remained empty. The General Assembly did not appropriate funds to it, and so the groundwork was laid, but we didn't get across the finish line. So in 2018, people started talking about the Regional Greenhouse Gas Initiative, RGGI, and that's a carbon cap and trade market. It involves 10 other New England and Mid-Atlantic states, and the market requires power producers to purchase allowances for carbon emissions in quarterly auctions, and then they distribute the funding to the participating states. But unfortunately, at the state level, just as Joe alluded to at the federal level, climate change got caught up in the crosshairs of politics, unfortunately, and it became a big point of discussion. The legislature blocked Virginia joining RGGI, but then there was a shift to a Democratic majority. And so the Clean Energy and Community Flood Preparedness Act was adopted, and that's in your handouts, so you can read that at your leisure. And as a result, Virginia ended up joining RGGI in January of 2021. Virginia's law required half of the auction proceeds that we get to go to low-income energy efficiency projects and 45% of the auction proceeds to go to the newly reconstituted Community Flood Preparedness Fund, formerly the Shoreline Resiliency Fund. Senator Lewis modified it and revised it. And at least a quarter of those funds must go to projects in low-income areas, and priority must be given to projects using nature-based solutions, meaning green infrastructure. So not talking about the gray infrastructure like seawalls, but more of created marshes, wetlands, living shorelines, etc. We've had 3 auctions now. RGGI revenues have outstripped early projections, which is wonderful. Since March, when we first participated in an auction, proceeds have totaled $142 million, and there's another auction remaining, so we're excited about that. In 2020, the Community Flood Preparedness Fund when it was created, became a game changer for Virginia, and that we now finally had some skin in the game when it came to funding. But the sad irony of that is that the more resilient that we become, the more we rely upon renewable energy, then the fewer dollars we get from the auction, so the fewer proceeds we get. So we'll have less money for resilience the more resilient we become. It's a sad irony. So the state, I will throw in that the state does need to look at other options as well for funding. But the applicants to the Community Flood Preparedness Fund can include local governments, planning district commissions, or our Virginia tribes. And funding is provided in 3 categories: for planning and capacity building activities, for flood prevention and protection studies, and for on-the-ground improvements, projects that strengthen flood resilience. On October 5th, the administration approved funding of 19 flood preparedness projects using $7.8 million. So that's a big chunk of change, not nearly enough, but at least it's something now. A small percent of the $64 million in RGGI funds that will go to that flood fund. And that's because it only represents the initial round of $18 million the state made available. They're doing grants this year. They are planning to go into providing loans from the fund next year. There will be revisions in January to the grants manual. As any new program has, it has growing pains and there's points that they need to work through, but there will be revising the manual somewhat in January, we're told. I've included the Virginia Clean Economy Act here on this funding slide because it really became also a game changer in incentivizing the market to get into renewable energy. It established a schedule by which Dominion Energy and American Electric Power are required to retire their electric generating units that emit carbon as a byproduct of combusting fuel to generate electricity. And they're required to construct, acquire, or enter into agreements to purchase generating capacity located in Virginia using energy derived from solar or wind. And that replaces the existing voluntary renewable energy portfolio with a mandatory RPS program. The Renewable Energy Portfolio Standard Program, the RPS program, had been in place as a voluntary program in Virginia, became mandatory. And so they're required, Dominion's required to produce electricity, and American Electric Power is required to produce their electricity from 100% renewable energy sources by 2045 and 2050, respectively. So the goal is to get us to 100% of carbon-free electric energy generated by 2050. So that's a big change in what's going on. And so next slide, Mallory. Thank you. So another thing that RGGI funds has enabled is our Virginia Coastal Resilience Master Plan, because RGGI funds were used to pay for the consultant Dewberry that was hired to help with that. The master plan was created by Executive Order 24 in 2018. And it's the development of it is facilitated by a technical advisory committee, also created by Executive Order, which means, red flag, no guarantee of continuation into the next administration. And I serve on that TAC, and I know that that's a big point of discussion among us about what's the next step that will happen, because it's not codified, it's in Executive Order. And then in 2018, to back up and give you the full history, the Special Assistant to the Governor for Coastal Adaptation and Protection was created in state law. But again, there's no staff and no research dollars attributed to that position. So although that's a step forward in the sense that it's in statute, it's not in just Executive Order, it needs funding to have a further staff associated with it in order to be able to implement the master plan. And the master plan is supposed to be done and across the finish line next month. We're very excited about that. After 2018 and 2020, the duties of the Special Assistant for Coastal Adaptation and Protection and the Department of Conservation and Recreation's role in floodplain management were expanded by statute, and the Chief Resilience Officer role was codified. Interestingly enough, it says in the law that the governor will appoint the Chief Resilience Officer. Right now, that is the Secretary of Natural and Historic Resources. Prior to that, it was the Secretary of Public Safety, and so therefore that law is within the Secretary of Public Safety's code section, but it would be up to the governor in the future as to whom they would appoint. And a very important point is that state staffing and funding of this master plan effort are necessary if any progress is going to be made. Otherwise, the master plan is in danger of going up onto the shelf. Governor Kane had created a climate change commission that came up with a lot of wonderful recommendations. That went onto the shelf. Governor McAuliffe resuscitated that and had resuscitated the Climate Change Commission. Again, things paused, and now Governor Northam has, by executive order, called for the Virginia Coastal Resilience Master Plan framework that was created, and now the master plan itself. But what is the future going to bring? These technical advisory committee members are volunteering their time. We all have day jobs, and so this has to be staffed at the state level in some way to really make this happen. We need a permanent funding source, and we need to have the staff to make it happen. At the local level, it's very difficult, particularly in our rural areas, to have the capacity to apply for the grants that are necessary to become more resilient and deal with climate change impacts. So creating a more permanent structure to support this is key. Next slide, Mallory. Research. Research is also a key component, because if you don't know what you're facing, then you cannot build the right infrastructure to respond to it within the state government. So in 2016, the legislature did fund the Commonwealth Center for Recurrent Flooding Resiliency, which is a partnership between Old Dominion University, the Virginia Institute of Marine Science, and the Virginia Coastal Policy Center. And it's funding to engage in research to support our resilience efforts. That is a statewide center. And I will note the Chief Resilience Officer, by the way, has a statewide focus, whereas the Special Assistant for Coastal Adaptation and Protection, as stated in the name, has a coastal focus. So we're moving forward in Virginia, but we're trying to figure it out as we go along, because we have the Chief Resilience Officer, we have the master plan, we have the Special Assistant to the Governor, we actually have a secure and resilient Commonwealth panel as well, trying to figure out where these pieces fall and how they all fit together well. Then also this year, there was a report issued Back in 2020, legislation called on the Joint Commission on Technology and Science, or JCOTS, to study climate change impacts in Virginia, and they called upon the Virginia Academy of Science, Engineering, and Medicine to produce the report. And VASEM, as they're called, pulled together an expert panel. And warning, I served on that, so I have some bias. I think it's a good report. But we came up with 4 recommendations, and that was reported back to JCOTS and to the legislature. Recommendation 1 was establish a structure for more effective collaboration and coordination in state government. Recommendation 2 is address gaps in policy and procedure. We called for a substantive budgetary policy and procedure for climate impact review as part of relevant state agency planning, a comprehensive approach. Recommendation 3, create a body to coordinate and support critical data collection and technology transfer across the Commonwealth. Again, we have to have the data, we have to have it disseminated. And then recommendation 4 is provide meaningful economic innovation and incentives to build a resilience economy in Virginia. That's very important, that as we become more resilient, we build this economy to deal with the rising water levels and the other impacts as well, heat and increasing severe storm events. All right, for challenges. Next slide, Mallory. Thank you. We have some issues, some challenges in addressing climate change with our traditional environmental law paradigms. We are stovepiped by media. We have our air laws, we have our water laws, we have our renewable energy laws. Everything is stovepiped by media traditionally, and climate change is something that it's across the media. It's also across all the different kinds of secretariats within Virginia. It involves transportation and housing and natural resources. And so it takes a more holistic combined response. In this area, we also are subject to the Chesapeake Bay TMDL, Total Maximum Daily Load requirements. And that's, of course, an extremely important program we have been dealing with for some years now, but it adds an extra layer of requirements and compliance and coordination that's needed. And so we have to look more and more at best management practices, for example, that produce multiple benefits if we're going to really be able to address both of these challenges. Our regulatory programs tend to be based on past conditions, not predicted ones. So for example, even our funding decisions like VDOT makes through the Smart Scale program, the Commonwealth Transportation Board, tended to look at past storms, not projected storms. And when we're looking at stormwater regulations, you know, we have had them based on what's happened in the past, but what's happened in the past is not what's going to be happening in our future. So that makes it difficult to address through our regulatory programs as well. So we need a more holistic view of climate change mitigation and adaptation measures that are needed. So bottom line is the feds are not going to save us. And so we have to look to the state for that more holistic response. So I'm turning it over to Justin to talk about that. Thanks. Justin, are you there? Okay, I don't know what's happened there. So how about if we go, Mallory, can you put up Carrie Atwood's presentation?
Sure.
Thank you. Carrie, are you ready to go?
I'm ready to go. Thank you, Elizabeth.
Thank you.
Good morning, everybody. Just give me a second until there we go. Thank you, Mallory. We're going to talk about the impacts of climate change and environmental injustice on wastewater infrastructure today. Next slide. Next slide, please. Oh, I'm sorry, you got it. So first, let's talk about the scope of the wastewater infrastructure issue in Virginia. I'd like to provide a quick overview for you to talk about the septic and well issues that we are currently facing. There are approximately 1.1 million on-site sewage systems in the Commonwealth of Virginia, and there are more than 700,000 private wells. And usually when you have an on-site system, you have a private well. On-site systems usually exist in rural areas that are not close to our sewer connections, so you're also likely not close to municipal water as well. Your average on-site sewage system will last 30 to 40 years, and that is if it is properly maintained and it is still functioning as it was originally designed. We know from VDH records and from US Census data that nearly 50% of all the septic systems in the state of Virginia, so over 500,000 systems, are at least 40 years old. So we know that 500,000 systems in Virginia are at or near failure today. We also know that a number of households don't have adequate wastewater treatment at all. They either have straight pipes leading directly from their homes to ditches or to our waterways, or they have an illegal system that was never properly permitted. No one ever looked at the design of the system that was placed in the ground, or they lack indoor plumbing altogether. There are a number of households and communities in this Commonwealth that have no indoor plumbing whatsoever. And in a report by the Rural Community Assistance Project, which you can see a picture of the title page on the slide here, they found that 40% of homes within the Commonwealth that lack indoor plumbing are from Black households. Black households make up only 20% of Virginia's citizenship overall. We also know that the impacts of climate change are being felt across the state, but particularly in our rural coastal areas with low-lying areas with inundation from rainwater and rising sea level rise. And additionally, this flooding also affects the private wells that we talked about previously. However, private well construction there's only one bacteriological survey that is conducted, and that is when someone receives a construction permit for a private well. There is no ongoing sampling required by statute or regulation for a private well. So we have no way of knowing when a private well has been contaminated by a failing sewage system, or it's being inundated by salt water from sea level intrusion, or if it's being contaminated by mining activities. We have no way of knowing currently. Next slide, please. Talking about the impacts of climate change on our wastewater infrastructure, you see two pictures here on the slide. The picture on your right displays a permit that was issued in 2002 in Lancaster County, and it's showing two sewage systems. They are highlighted there in the yellowish green color, and hopefully you can see from the slide that they are at least 70 feet from shellfish waters of the Chesapeake Bay, which is required by regulation. And you can see a little orange circle at the top of the sewage system there, noting the beginning of the drain field. And at the time that this permit was issued, that little orange circle was 112 feet from shellfish waters in the Chesapeake Bay. The picture beside it on the left, you see the yellow arrow. That is the same spot as the orange dot in the permit in 2002. Clearly, we are no longer 112 feet from shellfish waters. We are right smack dab in the middle of shellfish waters. Many of Virginia's coastal communities have a moderate to high level risk of sea level rise, with a large number of those communities largely reliant on on-site sewage systems because they are in rural areas. Recurrent flooding due to the sea level rise can cause the septic system failure that we've been talking about today. Septic systems use naturally occurring soil profiles to help with the treatment of effluent once it's been dispersed to the drain field. Once a septic system becomes inundated, either through excessive rainwater or rising sea level, it can no longer provide treatment, and we have the wastewater effluent discharging directly to groundwater. Next slide, please. So VDH understood that these issues were going on, and we wanted to find a way of identifying where these systems were that were susceptible to sea level rise, where failures had previously occurred, and a predictive tool to understand where failures are likely to occur in the future. We worked with the Virginia Institute of Marine Sciences to develop the wastewater data viewer, and here is a screenshot from the wastewater data viewer right here. You see the varying levels of the color red. It's conducting a hotspot analysis. It's using data from VDH from the past 10 years for noted failures. And we only know that a system has failed when someone comes in for a repair permit. So it's a self-reporting system. So obviously it's not perfect, but that's what we've got right now. So it has that data in there, along with some other data that we'll talk about here in a minute, to help us really focus in on these communities that are likely to have widespread septic failures in the near future. Next slide, please. Okay, so this is us zooming in on Gloucester Point, and you can see that it has a number of hotspots here. So this would be an ideal community for us to focus on finding some sort of repair solution on a community-wide level. The varying levels of blue that you see there is projected sea level rise in the near future. And we also have a data layer in there to provide us with knowledge of where sewer connections are currently and where possibly sewer connections could occur in the future. Hopefully this will be public facing soon. We're working on getting that going. Right now, this wastewater data viewer is only for areas east of I-95, but we will be working towards extending that for the entire state. Next slide, please. Some parts of rural, coastal, and non-coastal Virginia are within areas that VDH defines as wastewater islands. These are areas where individuals and communities do not have access to affordable wastewater solutions that are protective of public health and the environment. Often, these are historically disadvantaged communities that were forced to build on less desirable land, or due to climate change or some other event such as diversion of water due to building projects, the land can no longer provide adequate wastewater treatment for the on-site systems. Homeowners in these communities often cannot afford to repair their systems. To repair an on-site system can be anywhere from $10,000 to $40,000 onward. It just depends on the site that the system is on and the size of the system. That is more money than many people make in a year in many of these communities. If they can afford to repair their systems, it's usually not the repair that is most protective of public health, their health, or the environment. It is what we call a Band-Aid repair, something to keep the sewage from coming to the ground right now, not something that's going to keep your private well safe in the future, your neighbors safe, or the environment. Counties and municipalities in these communities also cannot afford to extend their sewer connections currently to outlying areas that have no affordable wastewater solutions. Next slide, please. This slide is also part of the wastewater data viewer that we've been working with VIMS for. This is the identification of VDH projects. So this is where we want to focus our efforts for repair or replacement with community systems or sewer connections. What we did was turn to the local knowledge of our environmental health managers who are located in every district in the Commonwealth to use their local knowledge of communities to identify environmental justice communities, to identify what the issues are for that community, what the best proposed solution may be, and what an estimated cost for that solution may be. This area that you see here is in far southwest Virginia on an area that was impacted by mining activities. And we have a lot of straight pipes from that community, so that would be one that we would be targeting for a community-wide assistance program. Next slide, please. So on top of climate change and environmental injustice, the legal structure that was really doing homeowners no favors here. The legal structure, unfortunately, operated to penalize those who did not have the money to repair their systems. VDH was stuck with either taking a criminal action against a homeowner or seeking civil penalty fees or getting an order from the court to force a homeowner to repair a system that they could not afford to repair, unfortunately. We had no consistent funding to help homeowners repair their systems. All we had was penalty tools. We had no tools for assistance. And additionally, we had nothing in our regulations to deal with the impacts of climate change for the design and placement of these systems. VDOT has been considering the effects of climate change in its transportation planning for a long time, and VDH needed to do the same for wastewater infrastructure. Next slide, please. Well, it's not all doom and gloom. Finally, in this last legislative session, Senate Bill 1396, this landmark legislation did a number of things to address the issues we've talked about here today. The first thing it did was recognize the universal right for access to wastewater treatment that protects public health and the environment and supports local economic growth and stability. It prioritized collaboration among local, state, and federal government entities for funding to address wastewater needs with a preference for community-based and regional projects as opposed to cumulative, repetitive, side-by-side fixes. It also called for the incorporation of the effects of climate change into wastewater treatment regulatory and funding programs. So now VDH can look at climate change impacts on developing its regulations in collaboration with stakeholders and the Virginia Institute of Marine Sciences. It also authorized the State Board of Health to use the on-site sewage indemnification fund to provide grants and loans to assist homeowners with repair and replacement of failing on-site systems. This is a fund that we previously had in place, and it was to assist homeowners who had a system designed by VDH and installed by VDH, which failed, to get redress from VDH. However, VDH has not been designing or installing systems for a number of years now. We've moved to entirely privatization of that industry. So that fund was sitting there with funds in it that we could not touch for anything other than indemnification until this legislation allowed us to do so to help owners repair and replace their systems. Next slide, please. And VDH was excited to hear that funding for septic and well improvements was included in the state's budget for the American Recovery Plan Act, the ARPA funding. The budget will provide VDH with $5.75 million in fiscal year 2022 and another $5.75 million in fiscal years 23-24 for a total of $11.5 million in septic and well funding. And it specifically is for homeowners at or below 200% of the federal poverty guidelines. Now, this seems like a lot of money, but if any of you have been involved in any utilities and extending sewer lines, you know it's not going to go all that far, but at least it's something, and it's getting us on the right track. Next slide, please. So where do we go from here? We will be working here at VDH to amend our regulations to capture climate change impacts by working with VIMS, as we talked about with their models, and with our stakeholder groups to make sure that we are placing septic systems in appropriate areas that will have a useful life. We're going to identify impacted communities, EJ communities, utilizing our mapping tool and our local knowledge to try to provide community-wide help and assistance instead of the repetitive side-by-side nature that we spoke of previously. We're going to assist owners with repairing their failing septic or connect them to sewer when feasible with our ARPA funding. We're going to educate owners on maintenance and operation of our systems so the systems that we are replacing last for 30 to 40 years. And we will be able to work towards compliance with all the tools in the toolkit. So we don't just penalize people when they can't afford to fix their on-site sewage system. We can actually assist them in fixing their on-site sewage system. Next slide, please. This is just some helpful links and sources if you're interested. That first one is Senate Bill 1396 that we talked about. Next is a book called Waste, One Woman's Fight Against America's Dirty Secret, which is excellent. And everybody in the on-site program at VDH has been reading. It talks about a lady in Lowndes County, Alabama, that had a community with failing wastewater and the emergence of diseases we haven't seen for 100 years, such as typhus and hookworm, and the inability to extend sewer to this community. The community had no money, the neighborhood had no money, the entire county had no money in her fight to get wastewater solutions for this community. There's the Still Living Without the Basics that we talked about in the beginning report, which is very interesting. And the last is linked to the VIMS website that talks about the data viewer project that we spoke about here today. Again, it's not public facing yet, but hopefully it will be in the near future. Next slide, please. And this is just to remind us that failing on-site systems impact not only our public health, but also the environment. And we want to preserve Virginia's natural beauty for all the citizens to enjoy. I want to thank you again for the opportunity to talk to you today about the wastewater infrastructure issues in Virginia. And I'd be happy to answer any questions that you may have at the end of our presentations. Thank you.
Thanks, Carrie. And I believe Justin's going to come up next. And as Carrie said, please do put any questions in the chat box for the end. Thank you.
Thank you. Again, apologies for that hiccup in this virtual world, but I appreciate Carrie stepping in there. And I will now talk a little bit about the work that we've been doing related to climate change, more specifically in one of our DEQ programs, specifically within our Chesapeake Bay Preservation Act and the accompanying regulations. I'm Justin Williams. I'm the Director of the Office of Watersheds and Local Government Assistance, which includes our CBPA program. I did want to mention some of the two larger initiatives that DEQ are undertaking, and one of which obviously is specifically related to the discussion we're having here today, and that's really focused around climate change and environmental justice. The Virginia Code was amended to specifically outline, as a part of DEQ's purpose, is to address climate change by developing and implementing policy and regulatory approaches to reducing climate pollution and promoting climate resiliency in the Commonwealth, and by ensuring that climate impacts and climate resilience are taken into account across all programs and permitting processes. DEQ has really taken this initiative and additional purpose to focus in on 3 areas. That's resilience, adaptation, and mitigation, which is the capacity to anticipate, prepare, respond, and recover under the resilience umbrella, actions to help adjust to new or changing environments under the adaptation framework, and measures taken to limit the impact or causes under the mitigation framework. The CBPA amendments I'll talk about really hone in on the resilience and adaptation element of that focus. Do want to mention, because there is a lot of connection between these activities and initiatives, that of course the code was also amended for DEQ to consider and evaluate, along with the Commonwealth in general, environmental justice, specifically providing that it's a policy of the Commonwealth to promote environmental justice. And that effort has resulted in the creation of an Office of Environmental Justice at DEQ and continued work in this environment, particularly with identifying opportunities for increased coordination and communication. Next slide. So for those of you who may not be familiar with the Chesapeake Bay Preservation Act, it is codified in state water control law. It was codified in 1988. This is a state-only statutory framework. There is not a corresponding federal program like many of the other programs that DEQ manages or we've heard about here today. With the adaptation of the Chesapeake Bay Preservation Act, the regulations were first adopted in 1989 and have had a few subsequent amendments, one of which I'll talk about today. Chesapeake Bay Preservation Act, aside from being unique that it's a state-only program, also only applies to part of the Commonwealth. Specifically within the statute, there are 84 corresponding tidewater localities that are identified as being subject to the Act. That includes city, counties, and towns. And essentially, as you can see in the map there, it divides along the Interstate 95 divide between all cities, counties, and towns in the furthest eastern region of the Commonwealth, and largely are those that, of course, have direct connection to the Chesapeake Bay watershed. Next slide. Under the Chesapeake Bay Preservation Act, an important element of the work that we did looking at climate change, it identifies 2 types of primary Chesapeake Bay Preservation Act areas. Those are the resource protection and resource management areas. The resource protection area is the most critical element of the areas under the Chesapeake Bay Preservation Act. That includes tidal features as well as an additional 100-foot buffer from those tidal features. The resource management areas corollarily have an impact by virtue of areas that are identified as having potential runoff or impact to the resource protection area. And those typically are larger areas than you see with the RPA. Many of our jurisdictions, over half, have their entire jurisdictions identified as resource management areas by nature of the characteristics of those areas or the flow from them. Most of the effort and emphasis we placed when we evaluated climate change, as you'll see, was in this resource protection area, which is that area including the tidal features and immediate adjacent buffer, as you can see in the diagram there. Next slide. So the regulatory amendments and the efforts on climate change were the result of a 2020 General Assembly amendment to the Virginia Code and the Chesapeake Bay Preservation Act. Specifically, as a part of those amendments, there was criteria added for local government programs to encourage and promote coastal resilience and adaptation to sea level rise and climate change, and also another provision for the preservation of mature trees or planting in trees as a water quality protection tool as a means of providing other natural resource benefits. The way the Chesapeake Bay Preservation Act is established is, although it is a state level program and DEQ is responsible for general program oversight and review, the entire implementation and enforcement of the provisions under the framework are done by the locality. That's done through local ordinances and local programs to enforce the requirements of the Chesapeake Bay Preservation Act. And so essentially this amendment then required for local governments to include and consider coastal resilience and adaptation to sea level rise and climate change as a part of this framework for which they would be responsible for implementing. We obviously had to amend our regulations to provide specifically that criteria that localities would then adopt and incorporate into their local programs. That effort was finalized in June with the State Water Control Board approved amendments and became effective last month. Under these provisions, as you'll see on the next slide, we really focused on ensuring that when we're addressing land development, which is the primary consideration under the Chesapeake Bay Preservation Act, that there was a consideration of climate change along with the additional criteria that's already provided to ensure there is a balance between the economic development and the water quality protection goals of the Act. This regulatory amendment really focused in on ensuring both the climate change assessment as well as a consideration of adaptation measures to address climate change in these areas. Additionally, we did provide some limitations on the granting of exceptions by localities to the criteria that's established under the regulations, both related to these amendments and otherwise. And then, of course, because these provisions have to be adopted and incorporated by a locality, provided a 3-year time frame for adoption. Next slide. One of the key ways that we wanted to ensure that there was climate change consideration, since the primary driver for the program and consideration at the local level is looking at development in these areas, and in particular in that resource protection area that I mentioned, we did include in the regulatory amendment that localities shall assess the impacts of climate change and sea level rise on proposed land development within that resource protection area. We did provide that it should be part of the other consistent elements of the program and the applicability by the locality through their ordinances and processes to include this assessment as a part of their plan and development process. The RPA, the resource protection area, has to be delineated when there is proposed development in that area. And so the assessment is based upon the resource protection area as delineated at the time that an individual proposes that development. And we focused on a 30-year time frame, which is consistent with Commonwealth policy in other areas in terms of forecasting, or given the nature of the project, which could be less than 30 years, the lifespan. Next slide. One of the key elements in doing this and providing that assessment is the use of a model or forecast. We did specifically provide that's developed by or on behalf of the Commonwealth. And really there's 2 primary models or forecasts that are currently utilized by localities, and in particular utilized for looking at elements of climate change and resilience. And that's the ADAPT Virginia model that was developed by VIMS. But there's also the Virginia Flood Risk Information System that was also developed in conjunction with VIMS and the Department of Conservation and Recreation. Those are the current models of forecasts that would be recognized today under the regulatory amendments, but certainly these can change as there's continued growth and effort in looking at climate change impacts, modeling and forecasting. Next slide. Under this particular model and forecasting, aside from identifying the model, which, as I mentioned, would be ADAPT Virginia or the Virginia Flood Risk Information System, is what specifically localities should be looking for in terms of this assessment. And we focused in on 3 primary areas: sea level rise, storm surge, and flooding. Sea level rise, of course, is a huge element of evaluating climate change impacts, as we see sea level rise is a significant result of climate change. We focused in on requiring an assessment based on the 2017 NOAA Intermediate High Curve, which similarly to the 30 years has been a consistent approach by the Commonwealth in identifying the potential likelihood of sea level rise. And then we included storm surge, which of course can increase its intensity by virtue of climate change, and flooding, both the special flood hazard area and the limit of moderate wave action. This is a typical area that localities are already addressing, but of course is part and parcel with the potential impact you could see from climate change. By virtue of applying this model and forecasting, they're able to actually see what the specific results may be by virtue of seeing what the actual projection is for sea level rise in a particular area. Next slide. So by virtue of using that model and forecasting, it then leads to an assessment, and particularly focusing in on the potential impacts in light of what's being proposed on that buffer function, which is the 100-foot that I mentioned in the resource protection area. That buffer is designed by virtue of requiring to be vegetated to really maintain and protect the water quality protections that come along with the vegetated buffer. Given those particular impacts that could occur, the locality should, as a part of the assessment, identify conditions, alterations, or adaptation measures that may be necessary and appropriate, particularly if you are seeing something like significant sea level rise in the proposed development area. We have an existing tool and requirement under the regulations for water quality impact assessment, which is to look at that proposed development and the potential impact of water quality, particularly where you have some sort of reduction in the buffer function by virtue of increased impervious cover or structures. And this assessment can be included part and parcel with that assessment that's otherwise required. And then we actually provided provisions, of course, to empower local governments based on this assessment and the conditions and information as necessary and appropriate to actually require those conditions, alterations, or adaptation measures, which I'll talk a little bit about next, as a part of this proposed development. Next slide. One of those other elements of the regulatory amendments that we did, aside from ensuring the consideration of climate change impacts in this proposed land development, was to provide allowances specifically for adaptation measures in light of sea level rise and other climate change impacts. Because of the location of the resource protection area, and particularly that buffer, this is an area where you would anticipate a lot of individuals might want to install some sort of adaptation measure. We did put conditions around those installations consistent with the general Commonwealth policy, for example, with the change in the recent Virginia Tidal Wetlands Guidelines and the general Commonwealth policy under the statute to encourage flooding shorelines, but those adaptation measures must be nature-based. We did also identify a specific universe of which the adaptation must come from, including the Chesapeake Bay Program Partnership, the Stormwater BMP program, a shoreline protection strategy identified under the Tidal Wetland Guidelines and Guidance by Virginia Marine Resource Commission, or an eligible activity for funding under the Virginia Community Flood Preparedness Fund we heard about earlier as well. Next slide. Aside from identifying the specifics around the type of adaptation measures, there's additional conditions that, of course, it needs to be designed, installed, and maintained in accordance with the specifications specific to the adaptation measure and consistent with the general goals and requirements in place already under the framework, under the Act and regulations, is to really maximize that preservation of any existing natural vegetation, including mature trees, consistent with the other statutory change, as well as to minimize low end disturbance and comply with a few other requirements identified to ensure holistically that the adaptation measure could serve its function, but also serve the goals of the Act and the regulations. Next slide. One of the particular areas of focus in this effort is looking at and identifying use of fill. This has been a very frequently discussed topic within the framework of adaptation measures and climate change. Again, given where you may see these impacts relative to the RPA and that buffer area. We did look at existing work that has been done in this area, including by William and Mary Coastal Policy Center around the use of fill in these particular areas and provided for its use with certain conditions, really related again to ensuring its use under proper conditions, related to ensuring proper grading and sloping, that it did in fact support the growth of vegetation, that it's connected to an adaptation measure, and that any of the stormwater that you might, issues that you might have by virtue of this change through the installation of fill are addressed. And of course, that it complies with any of the other requirements. And in particular, that's the floodplain management requirements, which has very specific provisions in certain areas around the use of fill. Next slide. Additionally, given the interplay between the Chesapeake Bay Preservation Act, the Resource Protection Area, the allowances that we are providing, and these adaptation measures, and their interconnectivity with activities that might be undertaken to address flooding, and feedback that we received specifically from stakeholders and localities, we did want to provide and recognize that interplay. So we did establish as well that any allowance or approval of an adaptation measure should be consistent with that National Flood Insurance Program and any of the locality's ordinances. And we did not require a locality to approve or allow an adaptation measure in convention of their participation in the National Flood Insurance Program community rating system, for which has its own limitations around these particular areas, or may have its own limitations around these areas in order to get credit. Additionally, we did want to specifically address and recognize living shorelines, given the connectivity between the MRC's tidal wetland guidelines and the Commonwealth policies, but recognize the importance of promoting these activities. So we did provide for an allowance for localities to reduce requirements related to living shorelines, including whether or not they would require this separate water quality impact assessment. Next slide. One of the key elements here as you're looking at adaptation measures and the work that the MRC is doing is this effort related to shoreline management activity. Our regulations had existing provisions related to shoreline management activities, particularly around shoreline erosion control. What we did was work to reconcile that existing provision as well with the regulatory amendments around the adaptation measures. As you can see here, the adaptation measures, which are a standalone allowance for activity within the resource protection area, has those conditions that I referenced. We did still recognize the existing applicability of the shoreline erosion control measures and management. And again, that connects in with the tidal wetland guideline, which do establish living shorelines pursuant to the statute as the default and only allow for hardened shoreline activity under certain conditions, which are that not only is there active detrimental erosion, but you cannot install a living shoreline according to best available science. And it really recognizes a hierarchy of shoreline management activities. So while recognizing that if we're going to have a unilateral allowance for adaptation measures, we put conditions on that consistent with the existing framework and the goals of the Act and regulations, that we recognize in certain circumstances, especially with the application of the shoreline erosion control provisions under the tidal wetlands guidelines, that there is consistency for recognizing other shoreline activities such as a hardened shoreline consistent with that approach. Next slide. And one of the last elements that we really focused in on was looking at the ability for localities to grant exceptions, and particularly because of the importance of considering and assessing climate change and sea level rise, we did provide a provision that localities cannot grant exceptions to our existing criteria and requirements for what can happen in the resource protection area without considering climate change, or to allow for the use of fill the contravention of the requirements that we outlined, with a particular emphasis on ensuring consistency with other requirements and laws, including the National Flood Insurance Program and the flood management ordinances and provisions, both at the federal and local level. That is the extent of the activity that we really focused in on with our climate change work, making sure that localities were both ensuring consideration of these impacts as we're looking at development in these areas, as well as putting parameters, again, consistent with other activity, including the tidal wetland guidelines around allowing adaptation measures in this area. And I look forward to taking any questions at the end. And I believe at this point, I will turn it over to Mr. McFarland.
Hey, well, good morning, everyone. My name is Ben McFarland. I'm a senior planner with the Hampton Roads Planning District Commission. We're the regional planning agency for Southeastern Virginia. And today I'm going to talk to you a little bit about some examples of local and regional planning that has been done in response to projected climate change impacts. I guess to start off, just want to make clear that one of the issues that we're running into at the local and regional level is that there really is no mandated approach. There's no single kind of method that the federal or state governments have provided to Virginia localities to guide how this kind of planning actually goes along. And so for a lot of localities, particularly those that are most at risk from sea level rise or from flooding, they're trying to figure this out as they go. We're fortunate at Hampton Roads that we have a number of communities that have significant capacity at the planning and engineering level, so that they're actually able to put a lot of time and energy and other resources into it. But there's really no one-size-fits-all solution. And so what we've seen here in Hampton Roads is a variety of approaches that our localities have been taking. But just to reiterate, there really is no silver bullet to this. What works for one community or locality may not work for another. And so we're really still trying to figure all this out as we go. And so I've got 4 different case studies that I'm going to talk about this morning very briefly. The first one here is in the city of Norfolk. This is, they've done a lot of work on this topic over the last decade plus. One of the most interesting things that they have done most recently is the adoption of what they're calling Vision 2100. So if you're familiar with local comprehensive plans, those are usually, they look out about 25 to 30 years or so. So it's not a short-term plan, but it's certainly not a very long-term plan. This Vision 2100 was put together in response to the city's realization that sea level rise was a major challenge, and that looking only 20 to 30 years out was not going to be sufficient to helping the city actually address that. And so what they've done is they've looked at what the future risk is going to be from sea level rise, and then they've identified 4 different regions of the city where they're going to target different types of policy responses to that risk. So areas that need to be protected because of their value to the local and regional economy, areas that can be invested in because they are on higher ground relatively, but are also good opportunities for redevelopment, and then a mix of different types of neighborhoods that might be appropriate for either solidifying those communities or kind of coming up with some ways to adapt to more frequent flooding over time. Next slide, please. One of the more recent things that they have done is they've adopted some significant changes to their zoning ordinance. So Norfolk has had a very robust floodplain management program for years. That's the most typical place you might find a locality putting in place policies and regulations designed to address flood risk. What they have done in Norfolk is actually looked at not just flood risk now, but they're looking at all sorts of things together. So stormwater management, so that they can prevent their stormwater network from being overloaded, risk reduction when it comes to things like freeboard, not just in the 1% annual chance flood hazard area, or the special flood hazard area, but also in the 0.2% or the 500-year annual chance flood zone. That's a relatively uncommon policy, but something that a lot of our localities are looking at, and 2 of them have actually adopted that policy. So that's looking at applying freeboard requirements and flood protection requirements in a much broader area of the city than would normally take place. And then also looking at things like energy resilience. So what they have adopted in Norfolk is a requirement to either have alternative energy sources on site, such as solar panels, or to have a generator quick hookup that a homeowner or property owner could plug in the generator if power goes out. So that's, they've adopted these higher minimum standards that are applied across the board, but they've also adopted a more flexible way of implementing this requirement through something called the resilience quotient. Next slide, please. And what they've done here is that they've actually said, okay, well, we're going to require every development to do something for all of those different categories. But if you want to go the easy way, you can check off a few boxes. They have a set of tables in their zoning ordinance that would award different amounts of points for different types of activities in those things like stormwater management, risk reduction, and energy resilience. And then the different types of development, where it is or how big it is, or the type, whether it's a single family home, a residential or a non-residential development, those types of characteristics of a development plan would drive how many points it would need to get in each of those categories. So that's the kind of the easy way of doing it, and that's a much quicker process for getting your development approved and through the process so that you can actually get to construction. But the alternative to that is if you don't want to or can't do the point system, you can go through the typical site plan review process. So you still have to address a lot of these higher standards. But this process is it's a little bit harder, but this is the way the city is trying to incentivize people to use these types of activities that they've already identified as having significant benefits. Next slide, please. So the next case study I want to talk about is Hampton. So Hampton has taken a slightly different approach than Norfolk. I think they've kind of gone back to first principles in a way, where they've adopted or developed and adopted this resilient Hampton strategy. And this is a much more holistic planning approach that's really based on identifying what the community actually values. And these are those 8 values that they identified throughout this process. These are the things that they want to have, that they want their community to have. And they're not necessarily meant to be specific recommendations, but these are the things that the community values, and that they're using these values to actually develop goals and strategies to help implement those values. Next slide, please. So this is just showing here some of the strategies they've come up with that tie back to those values. You've got different policy approaches through zoning or through stormwater management, activities covered by or concerned with education and communication, putting data out there in a public format so that residents and others can access it, conducting outreach efforts, more typical policies and strategies such as that were designed to address issues in the physical realm, like protecting public assets, but also using public projects as demonstrations so that private development can see kind of how to actually do some of this more innovative work. And then looking at opportunities, when they're doing operations and maintenance of those existing assets or their infrastructure, putting in place sensors to help monitor the condition, but also looking at ways to save money when they go through the normal upgrade or maintenance process. Things like switching out older incandescent bulbs for LED bulbs, for example. That's one example that we've seen across the region where localities have seen significant cost savings, but there are others as well. Next slide, please. And then, I think the neat thing about the resilient Hampton approach, because they started with that assessment of local values, of community values, that they've been able to use that as a foundation for a lot of other work that they've done, whether it's work with, doing area plans, which you can see some kind of screenshots of the covers of those right now, or other kind of activities where they're able to kind of refer back to those values and then apply them actually on the ground when it comes to making decisions about specific parts of the community. Next slide, please. So if you're from Hampton Roads or if you're familiar with some of the work that's been going on in the region, Virginia Beach has been kind of at the forefront of a lot of the work that's gone into assessing the region's risk and their community's risk to sea level rise, but also in developing solutions. They've taken a much more engineering-centric approach to looking at kind of what they can actually accomplish as a locality, what they need to do. And so they started out with this very comprehensive approach that looks at, what is the risk to the city? What is the risk to the physical part of the city? What's the risk to the communities that live there? And then what are the options? You can see there on the right, the list of technical reports that they were able to accomplish over a number of years to really develop what I think is a gold standard for how to assess risk. Justin mentioned floodplain management earlier. We talked a little bit about flood insurance rate maps from FEMA, that those are kind of the baseline for how a locality might consider its flood risk. Virginia Beach has really taken that, turned it to 11, so to speak, and looking at not just what that baseline level of risk is, but really getting a sense of all the different ways that climate change is going to increase the city's exposure to flooding, and then to look at how they can analyze those risks of it, more frequent flooding to the city's economy, to its neighborhoods, and then to get a sense of kind of what the different strategies they could undertake, whether those are major structural projects, whether it's ways that an individual property owner can amend their site or can elevate their home or can do things on their property to protect themselves, and then also policies as well. Next slide, please. So this is just an example, this a diagram here that shows kind of what their approach was, looking at the impacts to start with, looking at what kind of options were out there in terms of possible adaptation strategies, then considering those comprehensively to develop an actual strategy. And right now they're actually in the process of figuring out how they're going to implement this strategy. For those of you, from around here, you might have heard there's actually a bond referendum that's on the ballot for next week, where the city has asked residents to chime in and to vote to approve a $500 million, billion with a B, bond referendum that would pay for the first phase of these strategies, and a lot of that information is available on the city's website. Next slide, please. So one of the things that I think is particularly interesting about the Virginia Beach approach is that as I mentioned before, there's no silver bullet here. In Virginia, we have very large counties and cities that all have to deal with risks into different types of communities, different types of development, different types of environments. And so Virginia Beach is, a very large city, has some pretty significant differences between the types of ecosystems and the types of neighborhoods and environments throughout that city. You've got the tidal eastern branch of the Elizabeth River, you have the Lynnhaven River, you've got the area around the oceanfront, and then you also have the southern rivers. And what the city has done throughout this process is recognize that what works in one part of the city may not work in another part. And so figuring out kind of which strategies are best suited for which types of neighborhoods, which types of development has been a cornerstone of their approach, and really something that we can use as a model for not just other communities in Hampton Roads, but communities throughout the Commonwealth and throughout the country. Next slide, please. And then, actually last year, in addition to some of the planning work they've done, Virginia Beach also utilized that analysis that they conducted throughout this process to adopt higher requirements as part of its Public Works Design Standards Manual. This is the manual that really tells both private and public developers, what kind of things they have to comply with. Justin mentioned some of the regulations that are at the state level. Virginia Beach has gone above and beyond those standards to incorporate things like sea level rise. So when you're designing a project, you have to account for a certain level of sea level rise, but also higher precipitation standards. So right now, most of our communities use what's called NOAA Atlas 14 Volume 2. That's the federal standard for precipitation levels. It's a little bit out of date, and it certainly doesn't include climate change projections. Virginia Beach's design standards actually do kind of correct for those deficiencies, and so that's a higher standard that they've adopted recently. Still working through kind of how that's going to, what kind of impacts that's going to have on development in the city, and my understanding is that they are going to be tweaking those as they go, but that's something that actually the region as a whole is starting to look at, and also the state as well to some degree. Next slide, please. And then the last thing I want to talk about today is this opportunity to that we have had over the last several years to really work more closely with our resident military installations. Hampton Roads, we're home to one of the largest concentrations of DoD assets in the entire country. Many of our residents have some direct connection to the military, whether they are currently in the service, whether they are a civilian employee of DoD, whether they're a dependent or a retiree. And so having, and in addition to that, we have a number of installations that are really located, right next door to communities. When they were first established, a lot of these installations were in areas that were relatively undeveloped, whether that's Langley Air Force Base or Naval Station Norfolk, that were in areas that were, or Oceana Naval Air Station, for example, that people hadn't actually moved quite a bit there. There was open space that was available, good opportunity for the military to establish these assets. But over the decades since those were established, many of these have experienced growth that comes up right up to the fence line. And so figuring out how we can work together with those installations, they're federal, they can kind of do whatever they want within certain limits. There are some state regulations that apply, but for a locality, working directly with a military installation can be a challenge. And that's where these joint land use studies come in. It's a federally established process. It's managed by the Office of Local Defense Community Cooperation, formerly known as the Office of Economic Adjustment. And it provides resources and a process to allow for localities and the military installations to really, work closely together to identify potential conflicts, potential challenges, and then to come up with strategies to address those issues. Next slide, please. So this is just an example here, a map of one of the more recent studies we've done. We just finished this one earlier this year. This is a study done with Portsmouth and Chesapeake and the Navy installations in those communities. Really, it does allow us to develop strategies. Having that planning resources there, the funding to do this kind of technical work, and then the process in place where we have local staff sitting down in a meeting with Navy staff or with Air Force staff, depending on the study, it's a great opportunity, and a number of our communities here in Hampton Roads have taken advantage of that over the last several years. Next slide, please. So a few closing thoughts on this one. just, to get back to what I talked about with the city of Hampton, it's really not just about dealing with flooding. It's about figuring out what our communities want to be right now, where they think they want to go in the future, and then balancing those desires with the need to protect from flooding. And so it's really about trying to address this issue from a comprehensive perspective. Coming from a regional perspective, I can see the importance of collaboration and coordination, but really sometimes it's just too much work. It takes too much effort. You don't always get what you want. And so it's important to take into account the relative costs and benefits of coordination. So sometimes it's important to work together, but other times it's really just best to do your own thing. And then maybe you can circle back and do some more collaboration later on if it's helpful. And we talk a lot about public development or public actions, but we need strategies for both. And right now that is I think one of the things where, as a Commonwealth, we're still trying to figure out exactly how that's going to play out. Next slide, please. So that's all I have today. Be happy to answer any questions. Just I guess one last thought, just that this is really probably the biggest challenge that communities will face from a planning perspective. It does touch on everything that we do. And if you would just imagine the thousands and thousands of decisions that have gone into making our communities the way they are today over the last 400 years, in some cases here in Hampton Roads, all of those decisions will be impacted in some way by climate change. So it's certainly not a sprint. This is a marathon. It's something that we're going to have to keep working on for the decades to come. Thank you.
Thank you. If all the speakers want to come back on, we'll go ahead and start the question and answer session. And I do have a few from audience members. If you would like to submit a question, now's a great time to do it. Hopefully we'll be able to get to your question. The first one here is for Director Andrews. Could you please elaborate on the meaning of a resilience a resilience economy?
Yes, I mentioned that as one of the recommendations from the VOSM report, the expert panel report that went to JCOTS. Don't you love that I used two acronyms in one sentence there? That was great. And probably the best thing I could do is read from the recommendation. It'll be much more eloquent than I could say, but the gist is that, we don't want to lose our ability to have thriving economies in light of, as Ben just said, this can be an existential challenge to a lot of our waterfront communities. And most of our waterfront is privately owned in Virginia. And so it's a real challenge trying to figure out what to do at the community scale, what to do at the individual scale, and also what to do at the business scale. How do we keep our businesses thriving? And one thing that's been talked about a lot is trying to develop this resilience economy of innovative technologies to deal with the climate change impacts. There is a program called RISE in Hampton Roads that Ben can tell you more about than I can, but it provides funding to innovative ideas, anything from ways to have sensors in the road to determine flood levels more quickly as it occurs, to elevating homes in an expedited fashion. But let me read to you from the recommendation in the report. We recommend that the General Assembly provide incentives for businesses to develop innovative resilience-enhancing products, technologies, designs, and services, to partner with universities to capitalize on their expertise, and to foster workforce development in building and implementing resilient solutions. These incentives could include such non-financial measures as expedited permitting, so that innovative solutions like green infrastructure can be rapidly implemented. However, funded incentives, including tax breaks for related R&D and capital investment, as well as grants and low interest financing, will also be important. So it's trying to take a comprehensive approach to enhancing our economy and what we can do to respond and be resilient.
Great, thank you, Elizabeth.
If there's a follow-up question, if I didn't answer that sufficiently, please stick it in the chat box. Thanks.
Thank you. Next to Carrie. Do you have any information about what percentage of schools in Virginia are on septic tanks and well water? If so, what supports are available to help the schools maintain the safety of their water access, and what requirements are in place?
So I don't have specific data for how many schools are on septic in Virginia right now. I can tell you that most public K through 12 schools are not on septic, but there are a number of private, smaller schools and daycares that are on septic. And the reason I know that is because it's come up to enforcement actions. So at that point, we try to help the people get the money they need to fix their system. Now we have a whole lot more money, which is fantastic. And I'd like to also talk to you about the Virginia Cooperative Extension's Virginia Household Water Quality Program, which provides for private well water testing in the Commonwealth. And they're a great resource if you want to get your water tested or the school wants to get their water tested. And a bit of foreshadowing, there may be some legislation coming forward about private well testing in the very near future.
All right, thank you. Next, we'll go to Justin. Are fence line communities defined in Virginia statute? How?
Yes, so in the definition section that accompanies the policy provision that I referenced in 2.2.234, there's several definitions. One of those does include fence line community, and it's defined as an area that contains all or part of a low-income community or community of color that presents an increased health risk to its residents due to its proximity to a major source of pollution. And then again, several of those elements are otherwise defined like low income community, and community of color, and those are all provided for in the statute.
All right. Joe, you're up next. Can you please briefly speak about the Juliana case and any implications for future climate change litigation that it might have?
Sure. So for those of you that don't know, Juliana is a case out on the west coast of California, specifically in the Ninth Circuit. And the Juliana case was a culmination of challenges. So after the attempts to create greenhouse gas regulations under existing statutory authorities, again, primarily the Clean Air Act, failed or at least stalled after the UR case, a series of lawsuits were brought in federal court to alleging or trying to establish an unenumerated fundamental right under the Constitution to, and it was labeled different things in different lawsuits. Some would say a right to wilderness, or a fundamental right to a clean environment, or a life-sustaining environment was the way it was alleged, specifically in the Juliana case. Juliana, by the way, were a collection of minors that brought a lawsuit. Juliana was one of them. They used the name plaintiff. So fundamentally what happened, though, is when it got up to the Ninth Circuit, in line with pretty much all other court decisions up to that point, other than the district court case that heard the decision, and which was appealed to the Ninth Circuit, held that fundamentally there is no there is no unenumerated constitutional right to a life-sustaining environment under the Constitution. And so the Juliana case represented what I'd like to call, at least at the federal level, the sort of the last major effort to utilize Article III federal courts to try to establish some sort of judicial institutional reform effort through the judiciary for greenhouse gas standards at the national level. So the consequence of Juliana, there's still some cases lingering out there, but by and large, any constitutional claims have essentially failed at this point, at least at the federal court level. The result of which is that a lot of the action in the judiciary is now at the state level. And so what you're seeing is a battle playing out, and these cases are all kind of still pending out there, is state plaintiffs, and generally and very often they're the municipality itself, either a city or even the state itself, bringing state-specific claims in state court. And those have actually garnered a little bit of traction, depending on the nature of the action that's brought. Some states like New York, for example, have a little bit broader reach because of the nature of the defendants being registered as publicly traded companies, and so New York has certain security laws that apply. So there is some movement in the state level as a result of the cases in the federal level leading up to Juliana. where you're seeing the potential for local greenhouse gas judicial decisions that might eventually result in some sort of quantitative emissions restrictions. The problem, though, is that the reason the cases were brought in the federal courts in the first place was because the federal courts have a broader reach and could help to define a more uniform national approach. And since those efforts have essentially stalled, while the local cases at the state level may have some positive movement, obviously those cases are only going to have the effect out to the jurisdictional limits of that court. And so if it's, for example, there are no cases pending in a Norfolk court, for example, let's say someone sued in a circuit court in Norfolk, well, depending on the nature of the claim, the court could rule as it rules, but the effect of that ruling is going to be pretty much limited to the city of Norfolk. And so that, again, feeds into Juliana was another step towards the continued fracturization of how greenhouse gas issues are being handled at the moment. So,
thank you, Joe. These next couple of questions are for the entire panel, so if anybody wants to speak up, feel free. The first, how does the 2100 plan get linked back up to the comprehensive plan?
I think that's for me. So that's just when they've done their Vision 2100, they just keep that in mind when they're developing their comprehensive plan. There's really no structured way of connecting those two documents. It's just a matter of consistency between the staff who know that it's there, and then looking for opportunities to take the lessons learned or the recommendations from the 2100 plan, and then just seeing how they can factor those in to the development of specific objectives and strategies that would be included in the city's comprehensive plan.
Thank you, Ben. This next one is more for the entire panel. Two-part. How many individual communities in Virginia, and this individual lists several districts, would be able to benefit from the lead hazard reduction program? That's part one. And then part two, what would the lead hazard reduction program from the Justice 40 initiative mean for disadvantaged communities' water supply?
I think that has Carrie written on it, doesn't it?
Somewhat. I'll take a stab at it. So I think it would be a benefit for across the entire Commonwealth. Certainly we have lead issues all over the state. They're not concentrated in one particular area. You usually find it in older housing, which we have stock of all over the state. And what was the second part to the question? I missed it. I'm sorry.
Let me go back to make sure I get the verbiage right. What would the lead hazard reduction program from the Justice 40 initiative mean for disadvantaged communities' water supply?
Well, I think it would mean, just like any of these initiatives that we talked about today, disadvantaged communities are facing the brunt of the issues that are associated with lead poisoning, as well as with, wastewater treatment and lack of appropriate drinking water. It affects, I think the studies can show you that it affects everything from education, their ability to focus, and where they go in life. It would be a huge deal to be able to help all the communities across the Commonwealth with the lead poisoning, along with every other environmental justice issue we've talked about today.
Thank you, Carrie. This one's pretty long, so bear with me. One of the largest challenges is how to interconnect and balance resiliency efforts with economic development, and to ensure that we keep Virginia poised for strong business and industrial growth, and even evolution based on renewable energy. This begs how we frame statutory and regulatory requirements, including restrictions on waterfront use and development, in a way that does not undercut commercial uses of property, while still providing for shoreline protection and adaptation. There are also different planning horizons for communities generally and business that can complicate this interconnection, and for any incentives for business. Can the panel speak to how we are doing so far in this regard, and what concerns are in play, and what opportunities exist for further actions to strike a good balance?
All right, I don't see anyone lunging for their unmute button, so I'll take the first stab at that. How about y'all? and I'll try to break this out into segments. Let's see. And if I miss something, please go back and reread it to me, Mallory. Yes, exactly. In that VASM report blurb I just read to you, I think that was the point there too, right? We have to recognize the need to keep our economy vibrant. And sometimes we engage in discussion about, there's this term managed retreat that has become loaded because it implies in some people's minds defeat, and in some people's minds it implies the whole community uprooting and leaving. And in a rural community in particular, if they leave, there's so much of their tax base gone. And so things that we talk about in theory have everyday real world repercussions, and getting from paper to reality, it is a lot, and it takes a lot of effort on the regulatory front and on the incentives front. For example, there's a working waterfront development area that was provided for in state code to help localities set up an area to incentivize working waterfronts to be operating, because we're losing those. Sometimes older operations, marinas or aquaculture facilities, whatever, at the waterfront may shut down for a while as an older owner retires. And then there's not an evident heir to the business, as young people maybe have left the area more. And so you can lose your grandfathered status and be surrounded by residentially zoned areas. So it's really important we try to protect working waterfront areas as we can. And that term encompasses, by the way, a lot of different kinds of business, right? A military facility, a naval facility is a working waterfront. But that's just one example of how I think the General Assembly has tried to realize that and recognize it with a code provision. But economic incentives will be necessary, and planning, I'm just channeling Ben here, planning is key, right? If we don't plan ahead for this risk, then we won't be prepared with the tools in the toolbox for, okay, we have a plan for this upland area. The Norfolk plan that Ben mentioned actually allocates throughout their jurisdiction that, this is the area where we want to see development go in the future to the higher ground. So planning ahead is key for all communities, cities and rural. But it's going to take a lot of effort and lift at the state level with the master plan effort as well. We had a number of different subcommittees. I chaired the finance subcommittee for the technical advisory committee for the master plan, and we did a lot of talking about how do we provide funding for all the different needs of these waterfront communities that they're going to be facing. And the RGGI fund is probably not going to be enough, frankly. It's not enough money. And as I noted earlier, the irony is that the more resilient we become in relying upon renewable energy, then the fewer dollars that we would have coming out of the auction proceeds. And so it's important to have other funding sources available as well. For private business and for citizens and communities. Ben noted it's a challenge we're grappling with private versus public property at times for grants and funding. I think that's an issue as well. But planning ahead is key, and funding is key. In fact, that's why those were two of the big categories that I talked about. And does anyone else want to pick up the baton on that?
I think the thing I'll mention is just, specifically when it comes to the regulatory, element, as I mentioned with the Chesapeake Bay Preservation Act, that act, even since its inception, recognized kind of this balance and necessity between water quality protection and economic development. And so when we undertook this effort and engaged with stakeholders, while we wanted to ensure, that there was an assessment, there was that planning and consideration piece, as you'll see in the regulatory amendments, it doesn't dictate a particular outcome. We want it to be very clear that, site conditions and needs are going to vary. But the essential part is that there is a reconciliation and consideration of that potential impact down the road, which I think benefits everybody, aside from ensuring there's not continued or future reductions of the buffer because of development shifts because of these impacts to what might be proposed today. I mean, frankly speaking, if you're planning to build something, it's probably helpful to know if it's likely to be underwater in 30 years, because that serves its own purpose. And so we really do have to recognize there's a balance between considering the impacts that you're going to see from climate change, how you react to those impacts, and then of course the varying interest from that from both the economic development as well as specific to the CBPA water quality protection. And really there's no one size fits all. It's key to ensure that we're looking at and evaluating what these impacts could be, and taking that into account when we're making these decisions.
Elizabeth, if I could just make a couple comments on this. One, I think that speaks to the importance of engaging with affected stakeholders throughout all these planning and regulatory development processes. It's really important for us to get a sense of what the pros and the cons of these different approaches are from those that are most directly affected. And then I think, you mentioned the importance of doing the planning work. It's extremely important to do the real analysis and planning, the engineering to get what those numbers are going to look like. We can talk about the different, generic types of adaptation strategies, but without doing the work that Virginia Beach has done or that Norfolk did with the Corps of Engineers, we're really just speculating until we get to the point where we can say this project is going to cost $20 million and it's going to have projected benefits of 30 million, over 20 years. Then we really can't make decisions until we have that information. And then I think the key thing that to keep in mind is that, this is a really good case where adaptive management is going to be crucial. We don't know yet what the impacts of these state regulatory changes are going to be. The wetlands guidelines just came out earlier this year. The CBPA regs, they're in effect now, but localities don't have to actually adopt those until, 2024, right? I think so, because they were just became effective earlier this year, a couple of months ago. So, figuring out keeping an eye on what those impacts are of how they're being used, what kind of costs they're imposing, and whether or not those are in line with what we as a Commonwealth want and what the legislature wants. I think that's just something that we're going to have to monitor over time to see if we need to tweak these programs in the future. And I would imagine that yes, we are going to want to change these programs over time. Figuring out what those changes will need to be, we'll need to just keep an eye on it and have these discussions ongoing.
Yes.
I'll answer just a little bit from the private sector. I will say, to answer the very last bit of that question, which is how we're doing so far. I can tell you, I think just from the nature of the tenor of this panel, that I think Virginia is doing actually pretty well, at least with regard to accounting for all the different perspectives, as Ben said, reaching out to all the stakeholders. I think the Commonwealth has always had a very collaborative approach to managing many of these issues and engaging with the stakeholders, which is not the case in a lot of other jurisdictions, where it's more of a command and control type approach, where the stakeholders, there may be a more adversarial relationship than what we're experiencing here. And it certainly doesn't help, especially in the Tidewater region. Nothing drives home the need to adapt to climate change like your front porch being 2 feet underwater and a developer not being able to develop property because the infrastructure is simply not there to support in 20 years when precipitation levels are going to be increasing well north of 20–30% than what we're seeing just a few years ago. So I'd say by and large, the Commonwealth has adopted a very balanced approach on how to adapt to climate change. I will say that a lot of harder decisions are coming, especially since climate change is accelerating. And so a lot of the decisions where we might have had the luxury of time to adapt, because the business community, the mantra is always the business community is always looking for certainty. And that's by and large true, but that certainty is going to be challenged as we need to implement policies at a faster clip. And so I think the regulated entities are going to find themselves having to adapt more quickly to the changing regulatory landscape and just the factual landscape. I mean, the environment's very different today than it was, a couple decades ago, and it's going to be very different just a few years from now. But by and large, I think we've struck a really nice balance so far, and I don't doubt that that's going to continue in the Commonwealth.
Thanks, Joe. Well, I see we're coming towards the end of our time, so I just want to stress that we tried today to provide you with an overview of what's happening at the federal level, and then also, and of course, the federal level, there's so much happening right now because the Biden administration issuing executive orders concerning climate change. But Joe did an excellent job of painting the tough path that we've had so far. And at the state level, thank you, Carrie and Justin, for describing how we're trying to break down those silos and cross those barriers. And Ben, thank you for an excellent job describing at the local level. When things aren't clearly defined at the federal level, it falls to the state and then to the local and regional level. And during this whole process, what we're striving to do, thank you, Joe, for saying the Commonwealth is doing pretty well. I hope so, but we're striving to keep in mind the planning, because we have to plan not just for our businesses, but for our vulnerable communities. And Carrie, I'm sure at VDH, you see that more than anyone with the septic impacts, and safe housing with safe water and septic is key throughout this process too. So thank you again for joining us. This, again, you have the materials, and this will be posted on the VCPC website eventually. And I hope you have a great rest of your day. Thank you for joining us.